candidates and then projected on an overhead projector in the strong room as the results were received. Well, I mean, this is evidence that is entirely based on the pleadings, because the pleadings raise the issue of what happened in the strong room before the declaration of the results. So paragraph 6 is entirely relevant. It's based on the pleadings. And my lords, I mean, it cannot be right that the witness statement's allusion to the availability of fax machines and the fact that those fax machines were not working part of the time, and one could see the frustration on the faces of many of the dedicated fax machine EC personnel and so on. My lords, that is evidence. It is obviously not something you plead. My lords, on the one hand, when your lordships pointed out to my learned friend that the objection is being made to evidence, not pleadings, he had to concede that that is in the nature of the. But in fact, when he actually talked about each of the paragraphs, he kept saying that it is not borne out on the pleadings.
Asempa FM.
We expected to see in the pleadings the statements that the witness is making in the witness statement. And that is not how the rules of evidence and the rules of procedure work. Because, my lords, there is a very clear distinction made between pleadings and evidence. There is a very clear distinction made between pleadings and evidence.
Mr. Chikata, regarding these fax machines, which pleadings relate to it? Which pleadings relate to the evidence that you want to?
The pleadings that relate to it, as I indicated, are from both the petition and from the answer. From the petition, starting with that, from paragraph 19 to 21, the pleadings indicate that she was required to act to comply with the Constitution. Then 20, that she acted in flagrant violation of the 1992 Constitution, and that she had a duty to act fairly, reasonably, and candidly. And then in paragraph 23, prior to her making the said declaration, Mrs. Jane Adukwemensah had been notified by agents of certain material errors.
Mr. Chikata, you see,
Asempa FM.
With this, your responses is that if you look at the entire petition from paragraph 1 to the end, nowhere did the petitioner plead. Nowhere did the petitioner plead that he even had 2 representatives in the strong room. Nowhere.
Yes, but my lord, the petitioner is not required to plead evidence in respect of...
That is a fact.
No.
That is a material fact. That even as a candidate, had 2 representatives in the strong room to take care of his interests. And then they can come in now and testify and give evidence as to what he saw or what he did at the and what happened. But in the petition indicating that even two
My lord, that is why I indicated to your lordships that in addition to what is in the petition, we have to look at what is in the answer. Because in the answer, the first respondent puts in issue the transparency and all that. The first respondent puts it in issue, as I indicated, and she does that, the first respondent does that explicitly in paragraph 5. Now, the petitioner has to answer the case of the first respondent. The first respondent says in paragraph 5, Roman 15, starting from the beginning, the first respondent says, CI 21,
Asempa FM
sets out a four-stage procedure for collating the presidential election results as detailed below. And this is an answer to what the petitioner is saying about acting in disregard of the law and the Constitution and so on. She says, this is the process that I followed. And she says specifically what should happen in the quaternary stage. The petitioner does that.
Now, Mr. Chikata, this whole trial, I don't see any issue brought to us regarding the process of the election.
No,
what you have brought to us is your difficulty with the declaration.
My Lord.
And the import of the declaration. Is that not it?
No, my Lord.
All right.
That is most certainly not it. My Lord, if that were all, why would we plead paragraph 19? First respondent and his chairperson, Mrs. Gina Adukwe-Mensah, are required in the conduct of their responsibilities in respect of elections to comply with the Constitution. Why would we plead paragraph 2? First respondent and his chairperson are required by Articles 23 and 296 of the 1992 Constitution to act fairly, reasonably, and not arbitrarily or capriciously, and to comply with the requirements of the law. Paragraph 23. Prior to her making the said purported declaration, Mrs. Jinja Adukwe-Mensah had been notified by agents of petitioner of certain material errors in the figures collated. That's not about the declaration.
Asempa FM.
That is about material errors that have been made. And the witness statement is drawing attention to how this paragraph 23, how was the paragraph 23 actually done? Because he says prior to making the said purported declaration, Mrs. Gina Adukwe-Mensah had been notified of certain material. So, a witness statement which is describing how she was notified by the agents of petitioner of those material errors, that witness statement cannot be said not to be based on the pleadings. Or paragraphs in that witness statement cannot be said not to be based on the pleadings. And my lords, I'm respectfully submitting also that it is not enough. It is not enough. It is not enough. It is not enough to. It is not enough to disregard the fact that the respondents have also put forward a case which the petitioner is obliged to answer. Now, your lordship said that There is no reference to the
Asempa
appointment of
FM.
agents and all that. And I respectfully refer your lordships to paragraphs 6 and 7 of the answer of the first respondent. The first respondent says that CI 127 provides for the candidates to appoint polling and counting agents for the various stages, and that the respective candidates in the just ended election, including the petitioner, appointed agents who represented them at all stages of the electoral process as said above. So there's a clear pleading about the appointment of agents.
Yeah, Mr. Kijikata.
The answer
It's not your pleading.
My Lord,
You built your case on your pleading.
yeah, but my Lord, respectfully, that is where I'm pointing out that it is not sufficient in determining what is an issue to refer only to the pleadings of the petitioner, because the petitioner also has to respond to the case of the first respondent. The petitioner has to respond. In paragraph 5, in paragraph 7, the answer that first respondent gives is that first respondent confirms that petitioner indeed appointed agents and stationed them at all the polling stations and collation centers, and goes on in paragraph 8 to say that petitioner's agents signed 13 of the 16 regional election results summary forms, while the agents of the second respondent signed 15 of the regional election results.
Asempa FM.
I mean, these are pleadings which the petitioner is obliged to answer through his witnesses. The witnesses of the petitioner must put the facts that are within their knowledge, which contradict some of the answers that are provided, particularly answers about what happened in the strong room. And my lords, I was referring to what is clearly provided in Order 11, Rule 7 of CI 47, which in this context, I believe, is adopted, which says that subject to this rule and Rules 10 to 12, every pleading shall contain only a statement in a summary form of the material facts on which the party pleading relies for the claim or defense, but not the evidence by which those facts are to be proved. So, for instance, my lords, if you say the first respondent acted in flagrant violation of her responsibilities under the Constitution and under the laws which she operated under, if you make that pleading and the respondent comes and says, no, I acted entirely in compliance, and here's what I did. Here's what I did. Is it possible to cut off
Asempa FM.
Can you mute? Actually, it's possible to mute from the control. So, my lords, if our pleading is that she has not acted in compliance, she says, I have acted in compliance, this is what I did, we are obliged to provide testimony that shows that it's not the case. And we don't need to provide the testimony as if we are only limited to the exact words of the pleadings. The exact words of the pleadings that we are put in are that she acted contrary to her responsibilities in respect of the conduct of the election. We say so. And your lordships, with respect, requiring us to provide the evidence of that cannot be justified, because we have a situation where not only have we pleaded that, but the respondent in answer says, I did so and so, so and so, so and so, including I had agents, and your lordships yourselves ask questions. You had agents all over the country. Your lordships' questions and answers were provided to the evidence, not only without objection, but at the instance of the respondents. All that has been in evidence clearly. So if all that has been in evidence, it cannot possibly be said that
Asempa
that is not
FM.
an issue in this case. It cannot possibly be said that. Now, my lords, in respect of the paragraph 23 of the pleading of the petition that I referred to earlier, your lordships will note that there is not only a reference to the fact that agents of the petition, and my lord, this is again a pleading which shows that we are referring to our agents. The agents of the petitioner took certain steps. Unless your lordship is wanting us to say agents were appointed by reference to a letter dated so and so and so. But we don't need to do that, because that is evidence. But we refer to the fact that the agents of the petitioner, who have also been referred to in the answer, they notified the first respondent's chairperson of certain things. And they go on to say that she refused to accept a letter written to her raising some of those concerns. So the actions of the agents in relation to what happened before the declaration, those actions are part of our pleadings. Now, my lords,
Asempa FM.
further, and we are still dealing with paragraph 6, which they object to. I will refer further to the answer.
Order, please.
The answer of first respondent in paragraphs 16 and 17. In fact, if I may start from paragraph 15, where the first respondent says, first respondent adds that during the process and as the collation proceeds from state to state, any outstanding objections are addressed, paving the way for the candidates or their agents to sign the forms where they are present and are satisfied with the resolution. Then the first respondent goes on. First respondent adds that prior to the 7th December 2020 presidential election, it put in place a system to deliver a seamless and timely collation of results. First respondent is stating that
Asempa FM.
106.3.
Only God can stop us now.
106.3 FM.
that the witness is are part of the system. They are part of the system that is being referred to. And what the witness is doing is addressing the actual operation of the system from the 7th of December. So, my lords, it cannot possibly be something not born out of the pleadings, because their pleadings talk about. And then in paragraph 17, she says, first respondent says that numerous requests for recounts at the polling stations and recollation at the constituency and regional collation centers raised by candidates and agents that were attended to in accordance with the rules governing the election did not allow of the answer of the first respondent. Paragraph 17. He says, numerous requests for recounts at the polling stations and recollation at the constituency and regional collation centers raised by candidates and agents that were attended to in accordance with the rules governing the election did not allow for the prompt tallying and collation of the results as expected. My lords, in paragraph 6 of the witness statement, the witness is testifying to what
Asempa FM.
and testifying in a manner that shows that this claim that is being made in paragraph 17 is actually not correct. It's not an accurate account of what happened in respect of the collation process. The witness's statement is directly contradicting that, because the witness's statement is referring to what happened in regard to the fax machines and their difficulties in operation. And in paragraph 7, which is also being objected to, in paragraph 7, the witness states exactly what happened, different, contradictory to what the first respondent is saying in response to the petition. The witness is saying that they say there were difficulties that were attended to in accordance with the rules. And the witness says, instead of that pre-arranged transmission system for the regional collation sheets to be transmitted to the head office of the Electoral Commission, what happened part of the time was that one of the deputy directors of the EC, that it should have been directors, but it says director. So Dr. Sribo Kweku would from time to time bring into the strong room what was claimed to be a regional collation sheet. How he got that sheet was not disclosed. Now, this is material testimony in response to what is stated in
Asempa
paragraph
FM
17 of the answer of the first respondent. This is very material testimony. Because, my lord, it really is serious if what this witness is testifying to happened as he's describing, as compared to what is required in CI 127. Because my lords will notice CI 127, not CI 127. an issue in this case, if there is an issue, facts about how recollation and issues raised by candidates and agents were attended to, and whether those were done in accordance with the rules governing the election, as they are claiming in paragraph 17. If there is an issue about that, with respect, the witness is entitled to give testimony that enables the court to know that what is being put before us is factually unacceptable. And I will see also that in paragraph 27 of the answer of the first respondent,
Asempa FM.
respondent avers that the presidential declaration form 13, which is a tally of the 16 from 12 transmitted with all the results from the Techiman South constituency and showing the total votes cast and the total valid votes, shows that second respondent won the 7th December 2020 election. My lords, PW2, the second petitioner's witness, stated in answer to a question from the bench that the form that was put, first of all, he said they never saw Form 30. That was his answer in earlier cross-examination. Then a question came from the bench where he was shown a so-called Form 13. And the witness stated categorically that that is not Form 13 under CI 127. That is material evidence of what happened. And my lord, that material evidence has gone in without objection. It was in answer to a question from the bench. And that material evidence shows that the first respondent's chairperson did not act in compliance with CI 127. That evidence is there on the record, and your lordships cannot turn a blind eye to a disregard of the Constitution
Asempa FM.
that has come before you in evidence. Your lordships cannot turn a blind eye. And if evidence is being read, further evidence is being read, which shows the non-compliance, which we have pleaded. We've pleaded that there was a non-compliance with the statutes and the Constitution and the due process provisions and so on. If further evidence is being read that shows, for instance, that Form 13 is indeed not what is provided for by law, the Constitutional Instrument 127. My lords, that is very material, because your lordships are obliged to ensure that the law is respected, especially when it comes to a matter such as this. And in paragraph 8, paragraph 8 that is being objected to. That paragraph says, my colleague Dr. Pesa Wright and I, and that is a reference to PW1, on many occasions pointed out errors in figures and words on the sheets that were brought in, which ultimately affected totals and assigned results. This sometimes
Asempa
led
FM.
to EC officials making phone calls on the basis of which they sought to explain and correct some of the things we pointed out. I cannot tell to whom those phone calls were made. I cannot tell if the calls were to EC officials or to some other people who were also involved in collation processes. There was no transparent process in this regard. Now, this evidence about
Mr. Chikata, would the court of law have admitted this, the last paragraph? I cannot tell if the calls were made to EC officials or some people who were also involved in coalition process. This is very, very speculative.
No, my lord, it's not speculative.
Somebody is talking on his phone.
We cannot tell.
My goodness.
But my lord, this is exactly what he said. He cannot tell.
So, in the evidence, then you must as well leave it.
No, my lord, carefully, I'm not aware of why the witness cannot say. I cannot tell to whom the calls were made, because he said that they pointed out errors. When they pointed out errors, some phone calls were made. He cannot tell. And he ends up by